So I wanted to provide an introduction to California's rulemaking process or the regulatory process. The state of California has over 200 state agencies, departments, boards, and commissions that, of course, make public policy through their authority to adopt regulations. This is part of the lawmaking authority that is granted to the legislative branch, but by statute, it transfers some of that lawmaking power to the executive branch so that these agencies and departments and boards and commissions and bureaus can all do their rulemaking. There's a wonderful list of the state agencies that have adopted regulations on the website of California's Office of Administrative Law, OAL. It's found at www.oal.ca.gov. The OAL website also provides direct access to California's Code of Regulations, the CCR, which is organized under about 24 subject matter titles. There are 28 titles, not all of them are used. These titles contain just over 60,000 adopted state regulations that are currently in effect. Now, California's rulemaking is governed by the APA, the Administrative Procedure Act. And California's APA, like its federal counterpart, contains required procedures for rulemaking as well as for administrative hearings that are overseen by the Office of Administrative Hearings, OAH. So these agencies and departments all have to comply with the APA. This statutory scheme is found at Chapter 3.5, Chapter 4, and Chapter 5, commencing with Section 11340 in the Government Code. It's in Part 1 of Division 3 of Title 2 of the California Government Code. In addition, there are actually regulations governing the APA process. These are found in the California Code of Regulations, Title 1, Sections 1 through 120. They deal with the Office of Administrative Law and the rulemaking process. You should also be aware that OAL's website includes checklists used by OAL to review regulations. They also have several publications, including California rulemaking law under the state APA. They also have links or drop downs to regular and emergency rulemaking and even so-called underground regulation petitions. Now, generally speaking, the authority of state agencies and departments to adopt policies, that is, engage in rulemaking, is defined and provided for and even restricted by an authorizing statute enacted by the legislature. Statutes usually prescribe each agency's authority to adopt policy, and of course, it's an established principle of administrative law that an agency cannot exceed its legally prescribed authority to regulate. On the other hand, many statutes confer broad power to a number of state agencies, particularly those that deal directly with the general public, like the Department of Motor Vehicles. And these statutory authorizations can be mandatory. The agency or department shall adopt regulations. Discretionary, they may adopt regulations, and they can be narrow in scope. For example, to adopt regulations to implement this section, or broad, an entire title or division, everything that is subject to that agency or department's jurisdiction. An important component of the APA process, both at the federal and state levels, is the opportunity for interested parties, and of course the regulated community, to be informed as well as to observe and participate in the rulemaking activities of these state agencies and departments. In particular, interested parties have significant access to rulemaking activities by virtue of following the APA. For example, every state agency is required to annually adopt a rulemaking calendar. It's published on their website. Agencies also are required to establish interested party mailing lists for notices of rulemaking activities by the agency or the department, board, or commission. When I began lobbying, it was a mailing list because, of course, we use snail mail. Today, you sign up and everything is communicated electronically over the internet. California law requires every state agency to also satisfy or comply with the basic minimum procedural requirements that are established by California's APA. And this, of course, deals with adding or the adoption, amending, or repealing a regulation. The only exception is where that agency is expressly exempted by statute, which I think is a bad idea. According to the Office of Administrative Law, California courts have long recognized that under the Constitution, the legislature may by statute delegate quasi-legislative powers to a state agency in the executive branch, so long as adequate standards are provided to guide the agency in that rulemaking. Now, the agency generally develops 4 required documents during the preliminary activity stage, which are needed to initiate the formal rulemaking process in California. The express terms or the text of the proposed regulation, the initial statement of reasons known by its acronym ISOR or ISOR, the fiscal impact statement, and of course the actual notice of the proposed rulemaking. And these documents are initially filed with OAL, the Office of Administrative Law, and then published by the state entity promulgating those regulations. Next begins a minimum 45-day comment period, which is an opportunity for interested persons or the regulated community to submit written, faxed, or email comments on all or any part of a proposed rulemaking. The notice of proposed rulemaking is published in the CRNR, the California Regulatory Notice Register. And the notice of proposed rulemaking is also mailed or emailed to interested parties and posted on the rulemaking entity's website. Now, again, according to OAL, a regulation must be easily understandable, have a rationale, and be the least burdensome, effective alternative. Moreover, OAL notes that a regulation cannot alter, amend, enlarge, or restrict a statute, or be inconsistent with or in conflict with a statute. And I would say that of the Constitution as well, of course. Under the state's APA, an agency has the option as to whether to hold a public hearing on its proposed rulemaking. However, if an agency doesn't schedule a public hearing and any interested person submits a written request to hold one within 15 days prior to the close of the written comment period, then the agency or department is required by statute to hold that public hearing. So because of this requirement, in many instances, agencies do schedule a public hearing. And usually that public hearing is held on that 45th day, the last day, for written comments to be submitted. Now, the APA also requires a rulemaking entity to consider all relevant information that's presented to it during the comment period, in writing or verbally, before that agency or department can adopt, amend, or repeal a regulation. And after the initial comment period, the agency often decides to change its initial proposal, either in response to the public comments it's received or perhaps of its own volition. Now, before a rulemaking agency adopts regulatory changes, it also has to mail a notice of opportunity to comment with a copy of the proposed text to each person who has submitted written comments on the proposal, or those who have testified at the public hearing, or otherwise asked to receive a notice of proposed modifications. The agency is also required to post that information on its website. The rulemaking entity is also required to summarize and respond on the record to all timely filed comments. The summary and response to comments demonstrate that the agency has considered all relevant material presented to it before it adopts, amends, or repeals a regulation. And an agency responds to a comment in one of 2 ways. Here again, according to OAL, the agency must either 1, explain how it has amended the proposal to accommodate the comment received, or the agency has to explain the reason or reasons for making no change to the proposal. And an agency's summary and responses to comments are included as part of what is affectionately called the FSOR, the Final Statement of Reasons, or FSOR. Thereafter, after the conclusion of the rulemaking, the agency has to transmit its rulemaking file to the Office of Administrative Law for review within 1 year from the date that the notice of proposed rulemaking was published in the CRNR. OAL then has 30 working days in which to review the rulemaking record to determine whether it has been demonstrated that the rulemaking agency satisfied all the procedural requirements of the APA. It only considers the rulemaking file. In other words, no independent comments can be submitted or considered by OAL unless we're dealing with an emergency regulation. So OAL reviews the entire rulemaking package for compliance with 6 statutory standards of review. They are authority, reference, consistency, clarity, non-duplication, and necessity. OAL is not permitted to substitute its judgment for that of the rulemaking entity with regard to the substantive comment of the regulations. Again, OAL's review is to ensure compliance with the procedural requirements set forth in the government code in the APA. So that is the essential rulemaking process to follow by statute and regulations. Now, again, there are a number of instances where interested parties can participate in the rulemaking process, both pre and post formal actions. After the rulemaking is concluded, parties can meet with agency staff, for example, even before a rulemaking can proceed. Many agencies and departments in the state of California also utilize what is sometimes known as an interested parties process, in which they may review draft rulemaking projects prior to commencing the formal OAL process. These are so-called pre-notice or pre-OAL or pre-APA processes, in which the agency or departments may come to the regulated community, for example, and either suggest rulemaking or perhaps solicit rulemaking from interested persons. Even after the agency or department has completed the formal rulemaking process, there are opportunities to be involved, such as appealing to the governor's office in certain limited instances, and ultimately challenging a rulemaking in Superior Court in the state of California.